Okay, hello everyone, and welcome to the Public Librarians Monthly Chat. My name is Julie Niederhauser, and I'm joined today with Freya Anderson from the Alaska State Library. And today we're going to be talking about public performance rights, specifically as they pertain to showing films in the library. So I think the first thing that we're going to do is a little true and false. And since it's just Freya and I right now, we'll just kind of have a conversation about this. But I think a lot of people believe that when they purchase a DVD that they own the rights and are entitled to show that film in their library. So Freya, is that true or false?
Well, that is false, and it's kind of a shame in a way, because it's intuitively it seems like it should be true, doesn't it? But in fact, performance rights are separate from other copyrights, and in particular, most DVDs that you purchase actually have license agreements. So even if the performance rights came with copyright, which they don't, the licenses almost always restrict that. Looks like we've got some more folks joining us.
Right, that's great. Hello everybody. Hello Katie and Kathy. My name is Julie Niederhauser, and I'm joined today with Freya Anderson from the State Library, and we're talking about public performance rights, and specifically as they pertain to showing films in the library. And we were just having a little conversation about the premise that a lot of people are under, that if they purchase a DVD, that they are entitled to, that they own it, and that as the owner of the DVD that they're entitled to show the film without any special performance rights. And Freya was just telling us that that's not necessarily true. If you have any questions, we welcome you to chat them. And I want to make sure that you guys are able to do that. You have the chat permission on, so that's great. So I was preparing for this webinar, and I was reading an article that Carrie Russell from the American Library Association, she's a copyright specialist for the American Library Association Office of Information Technology, that she had written a while ago, and it was entitled Copyright Concerns, Public Performance Rights to Show Films in the Library. And one of the things that Carrie states in her article is that the right to public performance is an exclusive right of the copyright holder. And in other words, the copyright holder has the sole rights to perform the work. And screening a film without prior authorization of the copyright holder is an infringement. But there are exceptions, just as there's exceptions in the library in Section 108 of the Copyright Act that allows libraries to make copies of articles and to make and distribute one and only one copy of an article. There is a provision in the copyright law that states that performance right does not apply to performance or display of a work by instructors or pupils in the course of a face-to-face teaching activity of a nonprofit educational institution. So in a classroom or similar place devoted to instruction. So teachers can use a film that they purchased at a flea market or check out from the library for face-to-face instruction in their classroom. So, Fred, is there anything you want to add about that exception?
I do. This is not my particular area of expertise in copyright, but while that right is available, and in fact that refers not only to films but also, you know, if you wanted to act out part of a play, say, or other kinds of public performance, but for many of the films that we would want to show in a classroom, that still might not apply because of licensing. And so you really need to look at any paperwork that came with the DVD or anything on the in the case, or sometimes there's a license at the beginning of the when you start to play it. And while there is some wiggle room, or maybe some wiggle room, generally speaking, licenses have, the courts have accepted that licenses will trump copyright. And so if there is a license that reduces the permissible use, then that would be most likely binding. And I should jump in here and say that, of course, I've been studying copyright, and particularly as it relates to libraries, and I try to keep up on it, but of course I'm not a lawyer.
Right. We should both state that, just because this is being recorded, that I'm not a lawyer either. I'm a librarian. And our goal here is basically to share the information that we have that's available. And always, if you have a specific concern, you should seek legal advice from your city or borough or whatever.
And the key is that instead of legal advice, what we're doing is we're just trying to work through issues that you want to consider.
Right. So sometimes libraries are not exactly sure of what a public performance is. So a public performance if the film showing is in a public space or in any place that a substantial number of persons outside of the normal circle of family and acquaintances gather, such as a restaurant, a meeting room, an auditorium, the community hall. All of those spaces are considered public spaces. And the reason that comes up is because you may check out a DVD and invite your family and friends over and view it without that being considered an infringement, obviously. So, do you need to obtain performance rights if you're viewing a film in your living room with your family or friends? No, because if you are privately viewing a film in your home with family or friends, that's perfectly legal. But as we mentioned before, there is the teaching exception. Screening a film for the purpose of a nonprofit education is non-infringing because of the copyright exemptions detailed in Section 110, which is titled Limitations of Exclusive Rights, Exemptions for Certain Performances and Displays.
Although, again, I need to throw in there, because everything with copyright is always more complicated, that if you don't have performance rights, it is possible that that there is a license that would restrict you from classroom viewing as well. And so, with that, you kind of you just kind of need to look at the license. And so sometimes it might allow, sometimes the license might allow that, might allow viewing in accordance with copyright. And then, and sometimes, if you're just doing a little snip or something, then you might, I guess my point is you need to use some common sense too.
Right. And what I've found in my reading is that there are, of course, exemptions even to the teaching exception, and that is if you are having a club. So if this isn't just your students in your nonprofit classroom, If it's a club made up of other people, then you would need to seek the performance rights. The other exemption was if you were inviting the public to your classroom for a viewing, then you would have to seek it. And if you were giving a film, like a film series, then you would have to seek the performance rights.
Or if it's not, the film isn't being shown for an instructional purpose.
Right.
So maybe you have parent-teacher conferences and you want to keep the kids quiet while parents and teachers are conferencing. And so you show videos that we used to do that when I was in high school back in the dark ages. And those would be considered public performances.
Right, and then the final one exemption was, of course, if it was a film that wasn't lawfully made, if it was, and I don't know how you would obtain a film that wasn't lawfully made, but I'm sure there was ways.
Well, if it's not a lawful copy.
Right.
So if you had a video, if your friends had a video and you copied it, odds are pretty good that it might not be a lawful copy. And then if you showed that, then that would, anything that you did with that unlawful copy wouldn't be lawful.
So Kathy, Katie, and Marguerite, do you have any questions so far about what we've talked about regarding performance rights? If you have any questions, do you have any questions about the teaching exception? Or no? Okay. Any questions about what what is involved in a public performance? Okay. Oh, looks like Marguerite might have a question. Not sure. Okay. So, just to follow up, do teachers need to obtain performance rights if students are viewing a film in a classroom or using the film for instructional purposes in their class? The answer would be no. Teachers and students can view a film that takes place in a classroom or is used for instructional purposes in their class. Of course, Freya did bring up the concerns about the licensing of the film. So Freya, how would they find out about that, about the licensing of the film?
Well, I mean, you see the example here in the picture where you have, it looks like a presidential debate, and presumably they're watching that as part of, for an instructional purpose. That's probably either live or taped off of TV, and that's not licensed. That's or in any way I haven't seen it where it would be. So that would fall under copyright law. Likewise, if there was a local video that was shot, maybe the students in the school, in a neighboring school or in a different grade shot a video. We need to remember that these performance rights are not just for Hollywood movies; they're for all movies or all video, and so you can get into these copyright exemptions when you're talking about video that is not licensed. Where you run into licensed video is usually when you're obtaining a DVD or a download of, excuse me, you know, a Hollywood video or a commercial TV show that's come out on DVD. And those are the cases where you would need to follow the licensing instead of copyright law.
Okay. Does anyone have any questions about what Freya just was talking about?
Looks like Katie may be typing.
Yeah. We really enjoy it when people ask us questions, because then we feel like we're not just talking into dead space. We want to know we have live people at the other end of the webinar. So please, we welcome your comments. Great. So if you've never used it before, you type into the little chat box and then press enter, and it will be displayed for us to see. Okay, use an example of video shot by another class. Should we get a release from that class before showing the video? Well, that's actually a really good question. I guess I would think that would be just polite and probably proper.
Well, and again, that's where you come into these copyright exemptions. So, you know, it's nice to get permission, but looking at and probably if it's from another class, they gave it to you, and so that permission is kind of implied. But do you need to get permission? And that's where you run into these public performance exemptions for classroom. So if you're showing that class as part of your teaching in your classroom, then that would probably, I would think, fall under an exemption. If you're showing that video just for entertainment and to support another class, then some permission might be needed. But that doesn't necessarily mean that you need to be really super formal about it. But yeah, that might mean that you might need some sort of permission.
Okay. I'm sorry, you guys, I had to take a quick phone call there. Was there any other questions, Freya?
Well, it looks like we have one here from Katie Baxter, but I'm still reading it.
Okay. So if there is a session in the webinar addressing increasing instances of public library and radio station or social media groups collaborating on programs involving story times, photo, and art types of displays. No, Katie, that's a fabulous topic, and we can certainly look into that.
I'm having a little bit of difficulty sort of understanding the question as to whether, I mean, you talk about collaborating with, say, radio station or social media. You mean like if the story time were sent out over the airwaves on the radio or that type of thing? Yeah. That can get really tricky.
Yeah, particularly if you're sharing, aren't those like the storybooks that you would be using, you'd have to get permission. It's okay to read them in the library, but not necessarily to read them on the air. Is that correct? Right.
And strictly speaking, if you just read copyright law really strictly, it seems likely that story hour is, well, at the very least, a fuzzy area on its own. But it's such an accepted practice. It seems likely that people would have a hard time, that anybody would have a hard time saying anything about that, and Carrie Russell, who you mentioned earlier, has actually said, yeah, you know, it's story time, that's what we do, go on ahead and do it. But to do that on the radio, where anybody can listen to it, it's very likely recorded, is a little trickier, and you might need permission from the publisher or author of the book that you're presenting.
You know, Katie, prior to setting this up, I actually called Carrie, and she's willing to participate in a webinar. So that's just something that maybe Freya, I know Freya has a really close relationship with Carrie, might be something that we could kind of facilitate. Because I think there's more and more libraries, probably more than just Kodiak, that are interested in this.
And she has sort of a Q&A, I guess, thing. It's not exactly a blog, but let me see. I'll take my mic off and see if I can find anything specifically about Story Hour in it. I know she's got. I went on ahead and pulled up her Q&A related to showing movies, so she does have that, and I can actually share that link. And the person we're talking about, Julie's on that. Great.
Okay. While Freya's doing that, let's answer this question. Do you need to obtain public performance rights if a screening is open to the public? And I think, as we mentioned before, that yes, you do. You do need to obtain public performance right if the screening is open. To the public. If you're going to show a film, like for example, a foreign language film to the community for cultural enrichment, or if you're planning on showing a children's animated film during a holiday party at the library, then you absolutely do need to have public performance rights to do so. Also, if you're planning to show a screening in a public space, so maybe it's not for a particular event, but like Freya mentioned before, sometimes it's raining and the kids have no place else to go, so you show a film. But other people are going to be entitled, or not entitled, but allowed to access that area. So if the access is not restricted, for example, if an instructor is showing a film to a class for curriculum-related purposes, but it's in a public or unrestricted access location, then yes, you do have to get the public performance right. And you also need to obtain public performance rights if you're showing a film to a club or an organization, or showing a film for a class, but you're also inviting others to attend. So if it's not, if you're not at home and it's not and it's in a public space and it's people outside of your normal circle of family and acquaintances, then yes, you have to obtain public performance rights. You know, Freya, we've talked a lot about when they need to obtain the rights. They need to do it if it's in a public space. They need to do it if it's open to the public, and if it's outside of the normal circle of family and friends, and if it's not in an instructional kind of setting. But what happens if they don't do it? I mean, what happens if they become if they infringe these rights?
Well, it's hard to say. Probably in most cases, nothing happens. Nobody, if the copyright owner doesn't find out about it and doesn't bring suit, then perhaps nothing happens. But that. I mean, we want to follow the law, even if we wouldn't get caught. But people do get caught too. So if we do, most likely a copyright holder would start off with a letter indicating that they believe there was a problem and asking for money. And They might not. They might go straight to a lawsuit. And in that case, again, they would ask for money, most likely. And then, of course, you'd have court costs and legal costs as well. Particularly with commercial items like I mentioned, professional movies and TV shows and the like, those copyrights are almost always actually registered. And so because those are registered and because they have they have plenty of lawyers for the most part, those I think are more likely to go to actually go to court. And if they do go to court, they're more likely to be really expensive, because if it's registered, then the copyright holder, and if they win, if it's decided that you did use the infringe upon their rights, then they can go for statutory relief instead of just for basically their costs. And those statutory amounts for infringement can get pretty high. There's two different levels depending on whether your infringement was sort of in bad faith or not. So if you knew you were doing something that you weren't supposed to do and did it anyway, then they may be able to get significantly more money than if you thought you were doing the right thing. You thought you'd gotten permission, but you didn't. Maybe you thought permission wasn't necessary, but it was. Then the amounts that they can get are much lower. But it can be hundreds of, gosh, I was just looking at the amounts yesterday, and I think it's like $750 is the bottom end, I think, and then it goes up to $150,000, and that's per infringement.
Kathy brings up a good point, and this is something that I've seen many libraries do. And I do believe that it probably isn't a good practice, and because that webinar I was watching yesterday from the Harvard instructor was talking about the Red Horn case, and the Red Horn case was of a DVD person who owned a DVD store, and he printed the DVDs. People come in, they rent them, and they take them home. But he also had a space in the store that he would allow people who didn't have equipment to come in and watch the film. And it was a public space because people are coming in and out. And he was fined $40,000 for allowing that to happen. So I can't believe that a library allowing people to watch a DVD in the library would be okay. But what do you say, Fred?
That's there are specific aspects of that case, and that's a really tough one. A lot of libraries do let people watch, especially when I was at UAF. I remember we used to watch course videos in the library, not as a group, just a single person checking that out and watching it. That's one where I think it kind of depends on the specific circumstances. So, you know, goodness.
Maybe we'll send Carrie Russell a question and share her answer with that.
I mean, well, I guess here's the thing. Most likely the library isn't actually doing a public performance in that case. It's some individual is checking out a DVD, and the library is providing the DVD, maybe providing the DVD, but they're providing the equipment. So if the library has DVDs that could be used on the equipment, where it would be legal for them to do so. So maybe if it's a school, they may have DVDs that they have performance rights for the class for educational use, and students are supposed to come watch that on their own, or perhaps they've gotten those public performance rights on some DVDs, or they have some sort of license. If they have that and there are significant non-infringing uses of that equipment, then how the equipment gets used, as long as they're not, carefully monitoring it, is really the responsibility of the user. If there is no use of that equipment, that wouldn't be infringing. So if they know that, say, you have to use a library DVD, it's not available for use on other DVDs, and they know that they don't have performance rights on any of their DVDs, and they know that there really isn't any circumstance for their community where it would be legal, then they might run into problems. But otherwise, I think and that would be not with direct infringement, but with contributory infringement. But as long as I think that as long as there's a significant legal use, then it wouldn't be the library's responsibility to police that. That said, it could be a problem for the individual.
And the other question is, now a lot of people actually will print out or check out a DVD, and then they'll use their own equipment because so many people have their own devices that they bring into the library. So that's another gray area that we have to check out.
Well, and again, if you don't know what, I mean, if someone checks out a play, they could go and they could read it out in public, and that would be illegal. But they also could take it and read it at home in preparation for a paper they're working on. And so a lot of the materials that we provide could be used illegally, but we assume that they're not going to be. And I think that's a valid assumption in most cases. And so we don't need to, when we're checking out materials, unless it's something that really there isn't a legal use, then that would be different. But as long as there's a significant legal use that they could do, we don't need to police them once they check something out from the library. Having said that, if we know that they're doing something illegal, then we should follow up on that, at least with the patron. For example, this is not dealing with public performances, but we had a lady come into the library one time, and she wanted to check out an interlibrary loan book. And she said that she told me that she intended to copy the entire book. At that point, I said, that I don't think that would be legal for the use that she was explaining to me. and so I can't check this out to you. If she hadn't told me she was going to do something illegal with it, she still might have, but I wouldn't have been responsible for that, and so I could have checked it out to her. At that point, she said, oh, I didn't realize I won't copy the entire book, and so I did check it out to her. Was she just saying that, or was she, or was she actually changing, her actions? I don't know. And so, I mean, we're libraries, we're not policemen.
That's true. So I just want to make sure that we answer all of Kathy's questions. She had made an earlier question about what does it mean for copyright to be registered. So
registering copyright is a formality, and it used to be in the United States, it was the law that items were not copyrighted unless you registered them. They weren't automatically copyrighted. And so you had to fill out some paperwork with the Copyright Office at the Library of Congress and provide them a copy. And there were certain requirements in order to obtain copyright. With changes in copyright law, that is no longer the case. Now everybody, if something is eligible for copyright, then you have that automatically. So as soon as something is in a fixed format that has a minimal amount of creativity and that you didn't copy yourself, so you can't copy a public domain book and have it be copyrighted. So once something meets those minimal requirements, it's automatically copyrighted. But you can still go through the process with the Copyright Office, fill out some paperwork, there's a fee. I don't know if you need to provide them a copy anymore, but there are some requirements for that. They're not huge. Well, but once you've gone through that paperwork, that fee, then that goes into their databases, and anybody can look up and say, that this book or video or whatever written by this person was registered on this date. If you do register, then it increases your ability to, well, it increases the amount of money that you can get if someone infringes, theoretically, at least theoretically. The ranges are pretty broad, so anyway, and it may help you in court. It may help the copyright owner in court, but you still have your copyrights. You still have the same copyrights. It's just sort of what you can do with them afterwards.
Okay. Well, I just want to get to, I know we're kind of running out of time because Freya had mentioned that she has to leave before 10, but I want to get to this last point, is that there's 3 different ways that libraries can obtain the public performance rights. You can purchase a film from some video distributors such as First Run Icarus Films, and you can purchase the film, and that film will have the performance rights included in the purchase price. You can also rent a DVD from some film distributors such as Swank, and as part of the rental price, the performance rights would be included in that. And then also some film distributors have a blanket license. For instance, I believe it's Movie License USA. You can purchase this annual blanket license, and all of the films that they have included under their umbrella will be covered. Now, the thing to keep in mind is that often what happens is some libraries will go ahead and purchase the blanket license and then find out that the film that they want to show isn't part of that film distributor's list of films. So, you know, it might be worthwhile to just do it individually. I don't know. Just keep in mind that obtaining a public performance rights means that the film's copyright holder receives compensation beyond the purchase price that you paid for the film, and that's a good thing because we want to compensate them for their creativity. And also keep in mind that copyrighted films are not automatically licensed for public performance. So anything else, Freya, before we close?
I just posted a link up here from the ALA wiki, which shows a bunch of sources, including some from Carrie Russell, regarding showing DVDs or videos in the library, or also it talks about music use as well. So it gives information, and it also gives some sources for clearing rights.
Okay, thank you, Freya, very much. Before we go, Kathy, is there anything new at your library? Any news that you want to share with us? This is part of the Public Librarians Chat. It's for librarians to share information about what's going on in their library. We heard from Katie earlier that her librarian, she's kind of hoping to maybe branch out, maybe do some storytelling or some other public performance stuff and share it on the air. Is there anything new at your library? Well, you know, that's a very wonderful sign. We're all excited about spring, and the last couple days here have been glorious. I hope it's been beautiful in Tok as well. I will let you know that yesterday Sue and Shane and I had a meeting, and we're planning a road trip, and we're planning to come visit Tok, and I think the dates we're looking at were July 21st through July 25th. We'll be taking a road trip and hope to hit 14 different libraries on the road system. So I'm really looking forward to that. So we'll fill you in as it gets closer to that. Freya, I want to thank you. It's always fabulous to have you on, and your breadth of knowledge of copyright is wonderful, and it's so helpful to know that we have an expert here at the State Library that we can turn to. So thank you again for participating in this webinar.
You're making me blush.
All right. Thanks, Kathy. Thanks, Freya.
Bye.
And everybody have a great day.